Judge makes a very questionable ruling in regards to the Bruen decision. Welcome to another installment of the Connecticut Gun Bench. Today's video is brought to you by P.A.N. Firearms, LLC. P.A.N. Firearms for NRA certification and multifaceted gun training. You can reach us at 203-300-6343 or use our website at www.panfirearmsllc.com. As always, there'll be a link in the description box below. And if you like my channel, like my content, and what I do here, you can support me with the link in the description box. Everything is appreciated. Let's talk about this here. Now, this is a judge out of Mississippi, and he ruled that the Second Amendment rights may not be removed for all violent felonies. Now, I kind of have a line drawn in the sand on this. It all depends on what the felony is. If it's tax evasion or some other nonsense, or if you committed a felony, you screwed up, cool, you've kept yourself straight, cool. I have no problem with you getting all your rights back. None whatsoever. But the person that he is ruling on is a violent felon. He was imprisoned for manslaughter, and then he was basically rearrested for fleeing law enforcement and aggravated assault on a police officer. This is the fine line that I'm referring to. This person has shown a propensity for violence. But I'm going to come right into here. And judge rules Second Amendment rights may not be removed for all violent felonies. On June 28, 2023, Judge Carlton W. Reeves, good last name, district judge in the Southern District of Mississippi and the chair of the United States Sentencing Commission, issued an order dismissing the case against Jesse Bullock for possessing a firearm as a convicted felon. Mr. Bullock was convicted of aggravated assault and manslaughter in 1992. He served about 15 years in prison. In 2015, Mr. Bullock was convicted of fleeing law enforcement and attempted aggravated assault of a police officer. He served 5 years of probation. Bullock was charged with knowingly possessing a firearm in May of 2018. Although for various reasons, the charge was not arraigned until October 2019. In June of 2022, the Supreme Court issued the Bruen decision, upholding its rulings in Heller, McDonald, and Catano. Mr. Bullock argued the Bruen decision rendered the ban on felons in possession invalid in his case. Judge Reeves spends pages showing how and why he disagrees with the Supreme Court. He presents several straw man arguments. Many courts have upheld the federal ban on the possession of firearms by felons in the last 85 years. The Supreme Court used historical records to determine what the Second Amendment means, not the desire of legislators or of judges. Judge Reeves does not like this approach, but he recognized it as required by the Supreme Court. Judge Reeves suggested he appoint a historian to research the historical record. Both parties in the case refused the suggestion. In Bruen, the burden is clear. Because of the text and history of the Second Amendment, it is the burden of the government to show a particular restriction on a rights protected by the Second Amendment was accepted and widely practiced at the time the Second Amendment was ratified. Judge Reeves gives brief summaries of the opinions in the Miller case, 1939, Heller, McDonald, and Bruen. He does some serious reasoning in determining felons are part of the people of the United States, as mentioned in the Bill of Rights, from order by Judge Reeves. This case asks the same question. If America's historical tradition permitted a felon to repurchase firearms after completing their sentence, why can't Mr. Bullock today? Judge Reeves waxes on about problems with the use of history to determine what is or is not a felony at the time of the ratification of the Bill of Rights. He takes considerable space to claim it is very difficult to determine anything with clarity from the historical record. Then he delves into the specifics of Mr. Bullock's case. He categorically states the action of Mr. Bullock possessing a firearm in his home is covered by the Second Amendment. Then he considers the problem of prohibiting felons from exercising rights protected by the Second Amendment from the order. Second, as Range explained, the phrase law-abiding responsible citizen is hopelessly vague 69 F 4th at 102. It cannot mean that every American who gets a traffic ticket loses her Second Amendment rights. 31 LD, but limiting to, quote, real crimes like felonies also misses the mark, because some modern felonies seem minor and some misdemeanors seem serious. The modifier responsible, meanwhile, is impossible to apply. In our republic of over 330 million people, Americans have widely divergent ideas about what is required for one to be considered a responsible citizen. Judge Reeves finds the government does not meet its burdens of showing a well-established tradition of laws near the ratification of the Bill of Rights. Judge Reeves goes on to throw doubt on the usefulness of originalism as a way to interpret the Constitution. He waxes eloquent in various versions of the "that was then, this is now" argument. His arguments essentially claim things have changed, so judges should be able to alter the Constitution to what they desire now. Times have changed, morals have changed, not for the better either. People have changed. From the next to last paragraph in order. Change is unstoppable, and to the extent Bruen and decisions like it try to stop that change, they will not last long. The only question is how long the people will let them remain. This is pure progressive ideology. Woodrow Wilson might have written it. Judge Reeves refused to admit words have consistent meanings. He refuses to admit to such a thing as human nature. Most of the examples he cites as different interpretations of the Constitution over time were not thrust on the government by the people. They were thrust on the people by courts who wished to impose their own policy decisions without being elected. Judge Reeves correctly applies the guidance to put forward in the Bruen decision. The difficulty he appears to have in doing so is he does not like the Supreme Court decision and thinks he could do much better. He never considers the work of judges to decide what the balance of interests are in a particular case is as easily as difficult as the interpretation of historical attitudes about the Constitution. Moreover, to place such power in the hands of the judicial branch is far more than the Constitution allows. So I'm going to come out of that. So the judge is saying, yes, the Bruen decision protects a felon's right to own a firearm, but because of modern society and, as he pointed out, change of morals and other standards, that he does not feel it fits. So this is something that's going to have to go back to the courts. The prosecution in this case is going to have to bring specifically, can a felon own a gun? And I've made my position clear on this. If you did something wrong, like, let him without sin, cool. If you've done something wrong and kept yourself straight, no issue whatsoever. If you are a habitual offender and violent offender, no. Common sense has to apply in that case only. I'm not saying that it applies to a person who is basically a good person being able to own what they call a modern sporting rifle, what the other side likes to call assault weapons. Two completely different situations. Because a violent person with a handgun is going to commit a hell of a lot more problems than a good law-abiding person with a so-called assault weapon. But I found this to be interesting, and once again, this is something that will probably have to go back to the Supreme Court. And it's going to come down to the question, can violent felons, listen to what I'm saying here, can violent felons, and I would throw in the word also habitual violent felons, should they be allowed to own a firearm? That's going to be the argument. But let me know what you think. As always, you can leave your comments in the comment section below. And as always, any statements of violence or statements that lead to violence will be removed. Please like, share, comment, subscribe. Don't forget to hit that notification bell so you're notified the next time a video goes live. I will see you on the next one. Peace.